Hello and welcome to the California MBA's DE&I Committee webinar for the first quarter of 2024. I'm very happy that you could join us today. California MBA is very proud of the work that this committee does to share information about how companies can either enhance or create a DE&I program within their own companies and what's going on in the area of DE&I across the nation. So I'm Susan Milazzo. I run the California MBA. I'm happy that I could join everybody today. Our committee chair, Ty Christensen, could not be available. So I will be turning it over to Stephanie Wittenberg with RWM Home Loans when we get to our program and today's speakers. Before we get started, though, I would like to thank PCV Mercor for being this year's DE&I committee sponsor. We're very grateful for the support that PCV Mercor has provided to this committee, and I'd like to welcome Candy from the company to talk a little bit about the company and their involvement with the committee.
Thank you, Susan. Hello, my name is Candy Sirarot-Paiboon. I am the Director of Client Relations at PCV Mercor, and thank you so much for having us on today, and it's a pleasure to be part of this DE&I webinar. In celebration of Women's History Month, PCV proudly recognizes the invaluable contributions of women in every facet of our society. Our team consists of talented women who bring expertise, creativity, and passion to their roles. With 58% of our staff being female, and 69% having a diverse background, we believe everyone should have a voice at the table. We understand that empowering women isn't just the right thing to do. It's essential for building stronger communities and driving economic growth. As an industry leader in appraisal management, we recognize the importance of diverse perspectives in driving innovation and excellence. With a foundation built on 43 years of experience, PCV Mercor brings a deep understanding of our clients' goals that complements appraiser modernization. Our use of state-of-the-art AI technology ensures precision and efficiency in every aspect of our service. To learn more of our future-ready solutions for today's appraisal management, please visit us at pcvmercor.com. Thank you so much for having us on today. I'll go ahead and hand it on over to Stephanie.
Well, thank you so much, Candy. And again, thanks to PCV Mercor. We appreciate your support. And with that, I would like to turn it over to Stephanie Wittenberg, our committee vice chair, who will introduce today's speakers and start our program. Stephanie? Stephanie, you are on mute. There is a button on the, there's a button, it is self-muted, so I don't know that, maybe that'll take, there you go. Sorry about that.
Sorry.
Little technological glitch there, sorry about that. We got you now.
Thank you, Susan. Thank you, Candy. Anyway, we are so fortunate to have Amber Lawrence, AVP of Diversity, Inclusion, and Equity and Inclusion of the Mortgage Bankers Association today, as well as Meredith Dante from Ballard Spahr, who is a partner with them. So Amber is the AVP of Diversity, Equity, and Inclusion from the Mortgage Bankers Association, as I mentioned. She's responsible for the strategic leadership and developing of an organizational-wide and developing inclusion framework, goals, equitable practices, member-facing DEI initiatives. She oversees the internal DEI team and a variety of task forces and special projects. With her background, I know she will have great insights for us today. And we also have Meredith Dante, partner of Ballard Spahr, where she represents employers across multiple industries. She regularly advises financial institutions and mortgage companies in connections with DEI issues, but also on wage and hour, discrimination, harassment and retaliation, and other employment disputes and issues. So I'm looking forward to her perspective from a legal lens. Thank you both for joining us today. Amber, let's start with you.
Wonderful. Thank you so much, Stephanie. To frame the conversation today, it'll be a little bit of a commercial, if you will, for the MBA. I know many of the California MBA's members are also members of the MBA, so this is really just designed to talk about some of the resources and kind of how we view our approach to diversity, equity, and inclusion. And we kind of organize it into 3 pillars or key initiatives, if you will. And one of those things is we aim to expand the diverse pool of candidates entering the industry and also retaining those diverse candidates to progress into leadership positions. And then we're also aiming to identify strategies for lenders to promote and access financial education for underrepresented borrowers and to expand that pool of diverse qualified borrowers and multifamily owners through financial education. So making sure everybody has the same foundational education and access to the same resources across the board, especially those who come from traditionally marginalized communities. And that final kind of bigger bucket or pillar or initiative is building on inclusion by promoting supplier diversity. And that serves in multifacets, and I'll touch on a little bit more on a later slide. Next slide. So as you can see at the bottom of this slide, the mba.org/diversity, that's where you can access this resource center that we have. And we have quite a few things. We have an online networking community that our members can access. It's more of discussion forum based, but there's also some announcements that we make as the MBA. And we're trying to connect our members for best practices with each other. We also offer a DE&I playbook. We launched that at the end of 2022. So we're now going into almost the second full year since we've launched that PDF version. It's really designed to help people across any, wherever they sit within the organization, to not only begin, but also further their DE&I initiatives. And when we recently launched, in conjunction with the playbook, a self-study web-based course. It's Foundations in Diversity, Equity, and Inclusion, and it is a self-study course. And both of those things are complementary and included with your membership at the MBA. We recently wrapped up our second cohort of the Developing Leaders Mentoring Program. That was something that we offered industry-wide, both to commercial multifamily and single-family members. So we had people from all various walks of life and all various roles within their organizations and within the industry, mentoring and menteeing. You can serve as both mentor and mentee through that program. And again, we recently wrapped our second year of that. We also offer some scholarships and awards. And I do want to focus a little bit on that. We're getting ready to launch our DE&I Leadership Award program and open up those applications for the 2024 cycle beginning in May. So in about a couple of months, and we'll run that through August, where organizations can apply to be recognized. There's no cost associated with that. It is self-nominating, so all you need to do is gather your folks internally and submit an application. And again, those things are managed and we evaluate. We have a judging panel where they are, all the applications are kind of judged against each other. So there's no necessary industry standard. But so we're looking for organizations who are really kind of walking the walk and talking the talk when it comes to equitable and inclusion initiatives. We also offer a bevy of webinars, not just on business topics, but also those that have a DE&I lens, and those are offered on our website as well, and these are complimentary. I did skip past a little bit of that scholarship. The Path to Diversity Scholarship is a program that we offer where those, it's open to everyone, with a strong emphasis on those who do come from traditionally marginalized or gender diverse backgrounds. We encourage them to identify such on their applications, where we offer $2,000 every year up to 3 times over the course of your career to not only take MBA education courses, but also attend some of the MBA conferences and events. Next slide. And now I just want to highlight too a few of the things and the partnerships that we have across the industry. One of the things I'm really proud of as it relates to mentoring, I did mention we offered a leadership, a developing leaders program for mentoring, but now we recently kicked off a pilot program focused mainly on students and pairing them with an MBA member company in an HBCU. So right now we currently have Wells Fargo and Bowie State University located in Bowie, Maryland. Together, there's a cohort of about maybe 25 students and 25 mentors from Wells Fargo actively engaged in conversation and developing their skills. And so far, so good. We're really excited about this and look forward to offering that later into this year and into next year in the spring semester. I won't read through all of these things, but I do want to highlight just really some strong collaborations. We work very closely with Fannie Mae and their Future Housing Leaders program. And again, this is really speaking to this building a diverse pipeline of candidates who will enter the industry. So this is mainly focused on a student engagement perspective. And we invite our members to also engage with these programs as well. MBA hopes to lead by example. So we hope to bring our members in to engage with some of these partnerships that we have. And the one on the last part of this slide is Home Free USA and their Center for Financial Advancement. And that's a representation at 15 HBCUs across, and HBCUs, let me back up, is historically Black colleges and universities across the country. And they're currently embedded on those campuses. And not only do they work with lenders and vendors and nonprofit leaders across the industry, we're also engaging students and not only inviting them to become more engaged and aware of the mortgage finance industry, but also providing them with the financial tools and budgeting options for them to become homeowners upon graduation. Next slide. And here are some of the other partnerships that we offer and that we engage with, and we also encourage a lot of our members to do so. These are the affinity-based groups, the National Association of Real Estate Hispanic Professionals, or NAHREP. It's an alphabet soup, if you will. The National Association of Real Estate Brokers, which is NAREB, and the National Association of Minority Mortgage Bankers of America, that's NAMBA. All of these organizations do wonderful things, not only at the national level, but also kind of drilled down at the state and local level, and focused on housing, focused on engaging those in the community. We also have our arm within the MBA called Convergence, which is fostering new solutions to different challenges, and those are place-based affordability challenges. And right now we're located in 3 cities, Memphis being one of them, Columbus, Ohio, and then recently launched in Philadelphia, Pennsylvania. And I believe this slide is going to, all of these slides rather, are going to be provided to the attendees today. So there will be more information for you to click on and kind of tinker around with. Next slide. And I do want to highlight our Commercial Real Estate Diverse Suppliers Consortium, and that's really touching on that third pillar that I mentioned kind of at the opening today, and that how we want to promote supplier diversity across the industry. And while it does say commercial in the title, it is designed to accommodate and help promote supplier diversity goals, both on the single family side as well as on the commercial multifamily side. But what this essentially is that we've come together in a consortium, and the list of the 5 other trade associations are represented here. And we've crafted opportunities through a vendor called Supplier Gateway for people to be able to identify and benchmark and have different reporting tools on how the spend is currently happening within your organization, as well as how you can get to be more diverse in your spending. What this consortium also does is try to provide opportunities for those who do identify as a minority or woman-owned business enterprise, or MWBE, and provide them with mentoring opportunities as well as access to capital. And then also just naturally what will happen is we're creating a diverse network of procurement professionals that share DE&I best practices. So this is called the CREDS Consortium. We love a good acronym. The next slide. And I did touch on this earlier, our DE&I playbook and foundational course. Again, this is a complimentary member resource and benefit that you get with your membership to the MBA. Again, just really designed for you to elevate your current DE&I initiatives, or if you're just starting on your journey or you don't have an internal DE&I practitioner, this is certainly something for you. And because it is a complimentary member benefit, it is accessible to everyone and not just those in DE&I roles or DE&I spaces. It's really just designed for anyone to kind of take a look and really engage and figure out how to best promote those practices, not only within your organization, but also maybe on committees like this. And again, just launched just a few months ago, our foundational course, the Foundations of Diversity, Equity, and Inclusion, that self-study program. It serves as a really nice complement to the actual playbook in PDF form. And I'll do the next slide. And I just wanted to touch on a few things that MBA is doing internally. And we learn from our members and we see all of the wonderful work that they're doing. And we'd like to adapt some of those things. We've been on our DE&I journey way before kind of the social uprising, if you will, of 2020, but definitely have put a stronger emphasis on things since then. And we've learned a lot from our members and how to advocate and how to promote those things within. So we've established some core values, and we call it shared values, shared success. And those 4 items that are listed, communication, inclusion, and equity and accountability, are the things that drive not only the things that we aim to do, but the things that we want to embody. And that's just not with leadership, that's across the board. We're engaging individual contributors as well as managers and executive leadership. And some of those things that we do in order to kind of promote that is we offer an employee-led resource group called Embrace, and they help with accountability, that 4th pillar that's identified here. We offer different types of training, and it is employee developed and facilitated. We're actually right in the midst of offering training right now to our entire staff. We do lots of historical and cultural religious celebrations and observances, regardless of whether we practice those faiths or identify with those cultures. All of our senior leaderships, as well as our middle managers, have identified intent statements. And again, that really is to promote accountability, how we hold ourselves accountable for delivering fair and equitable outcomes. And then we also offer monthly newsletter and webinars to our internal staff. And again, this is really mirroring some of the practices that a lot of our members have committed to. So we're honored to stand in lockstep with them. Next slide. Or it might be the last. This is the last slide for me.
Is it the last slide?
Yeah, it is.
Oh.
So yeah, here's how you can reach me. Amber Lawrence, alawrence@mba.org. My direct phone number is on here. I'm happy to walk anybody through any of the things that I've covered today, but I also look forward to engaging with your members with any issues that they might be having. We offer kind of somewhat of a resource when it comes to being a consultant. We do have those options within, so look forward to engaging with you all sooner than later.
Thank you, Amber. Those are great resources that you shared, and wow, really leading by example. So thank you. And real quick before I hand it over to Meredith, we will take questions at the end of the session. So if you all have questions, please feel free to drop them in the chat. Without further ado, I'd like to introduce Meredith. Take it away.
Great, thanks so much, and thank you, Amber. That's really such a great way to kind of set the stage for what we're going to talk about here, all of the great work that organizations have been doing, some for decades, some more recently, but I always learn something new whenever I join one of these webinars, various takes on different kinds of ideas and ways to enhance these kinds of programs and really create amazing workplaces. So I appreciate it. I jotted down a few notes myself, so that was great. So to maybe like a little bit more of I would say a skeptical segment of the presentation today, as I think many of you know or will soon learn, there was a U.S. Supreme Court decision last year that really has the potential to impact the work in the diversity, equity, and inclusion space. And we'll talk a little bit about how that may impact financial institutions and some of those of you on the webinar today. The Supreme Court case specifically addressed college admissions. So many of you might have seen it, heard it, and then you're like, wait a second, why are we hearing about it now? We'll talk a little bit about why and what might be in store for DE&I programs in the private workplace. So we could go to the next slide. So a few items I wanted to chat about with you today are just the background of Section 342 and Dodd-Frank. Again, trying to tie together some of these concepts and explain how this may be relevant to all of you as you continue on your DE&I journeys. We'll talk a little bit about this decision, what it said, what it didn't say, and what some of the implications of it are. And in particular, what the implications of it are beyond the university context, given that we're the MBA and not many universities, I suspect, on the line. And then also a little bit about what we're seeing play out. So it didn't take long for there to be attacks on DE&I programs, legal attacks on DE&I programs in the wake of the Supreme Court decision. And then finally, we'll close out with, like, what are you supposed to do with all of this information? How are you supposed to assess your programs going forward? What kinds of things should you be considering to potentially mitigate your risks? I will say that we had a flurry of boards, financial institutions asking these kinds of questions in the wake of this decision because there are fiduciary obligations obviously associated to shareholders, and some of those challenges are in the form of shareholder litigation. So it is very relevant. I think it's important to know enough to kind of be dangerous in this space to spot some of the issues. We're still seeing decisions come down. There's still a lot of uncertainty, but hopefully after this webinar, you'll have a bit more information and kind of understand what the key pressure point areas may be. If you go to the next slide, the next one. So we're going to start with Dodd-Frank. And so this was kind of a hot topic back in like 2018, 2019, when Section 342 of Dodd-Frank, sponsored by Representative Maxine Waters, introduced diversity and inclusion objectives. And there was a lot of discussion about the objectives for regulated entities, what was mandatory, what was encouraged but still voluntary. And there were several components, including that each agency that was subject to these regulations create an Office of Minority and Women Inclusion and develop standards for assessing DE&I practices with the various regulated entities. So there was a lot of discussion at the time about what does this look like? What should regulated entities do in response to Section 342? And if we could go to the next slide. So what were the overarching objectives with 342? So it really was designed to address the underrepresentation of women and minorities in financial services industry. And it was seeking to accomplish that through a variety of different mechanisms, but all kind of in the name of transparency, awareness, sharing information, and really focusing on trying to make the business case to financial institutions that this is good for business. This isn't just sort of a social program or something that's the right thing to do for other reasons. It can impact your bottom line. And there was a lot of reference to various studies and business review articles about the objective benefit of DE&I on workplace productivity and the bottom line. So that was a lot of the push at the time in connection with the literature surrounding 342 and a lot of the commentary too. If we could go to the next slide. So it had several directives, and I think a lot of people talked about this at the time, there wasn't a lot of teeth to this. A lot of this was more just like promulgating, you know, here's what we think is a great idea, and this is a really good thing for your institutions, and you should really consider doing this, and you should also share information with us voluntarily. But there weren't any real concrete requirements of a lot of the regulated entities at the end of the day. And so while the Bureau needed to create an Office of Minority and Women Inclusion, and they were required to develop these standards, there really wasn't a lot of teeth in how these standards were going to be applied, and the enforcement of these standards was a little soft. So if we want to go to the next one. Again, the purpose is laudable, and I talk about this here because a lot of the sort of guidance from and policy statements from this Section 342 echo a lot of the pillars. You know, we hear that term a lot, pillars that private companies were adopting, separate and apart from 342 when they were looking at DE&I programs and what makes a successful one. And so when we were talking about 342, we were talking about a commitment. So that's kind of low-hanging fruit. State that you're committed to it, figure out what's important to the organization, and be committed to it. And then the remaining four, I think, are, you know, pretty common. So the first one is workforce profile and employment practices. So, you know, your diversity statistics, your demographics, and focusing on your actual workforce demographics and taking a look at, you know, the varying demographics across different job profiles, across different job levels, applicants, retention rates, attrition, and really doing an in-depth dive to figure out what is your profile, where are you strong, where are you not, and assessing your workforce. The next was procurement and business practices. So that's a lot of supplier diversity. Amber gave some great examples of how organizations are working with their third-party vendors to increase supplier diversity and business practices with potentially minority-owned suppliers or vendors or other third parties. And then the promoting of transparency and organizational DE&I. So this was a big part of what Section 342 was aimed at, which is being transparent about it, talking about it, sharing information, disclosing it, and letting people know your commitment and how you're doing. And then the last one was a self-assessment. And the agencies really were looking for people to do these self-assessments across a lot of these various topics, and then disclose that to their respective regulator, so that the regulator could see, you know, what are we doing in the financial services industry? What's the landscape look like? What are some of the problems? So kind of utilizing this as a way to say, not only is this good for you to take a look at it, but also give us the information so that we can better understand the lay of the land. Go to the next page, next slide, please. But there were lots of challenges with that, and I was not surprised that the self-assessment compliance was low. I attended the 2019 MBA conference where a lot of us were speaking on this, and we were advising everyone not to share their self-assessments with the regulator. And not because there wasn't good reason for the regulator to want this information, or that it would be really helpful in developing maybe more concrete standards, enforcement practices that ultimately would better the industry. It had nothing to do with that, but everything to do with, generally speaking, disclosure to regulators of information gives regulated entities agita, and for good reason. And so, and it's sort of the no good deed goes unpunished. A lot of these self-assessments may reveal certain issues, certain patterns, certain things that could potentially lead to litigation. So there were very real legal risks and concerns associated with this. So unfortunately, Congress, not happy that their plan didn't really work and they weren't getting a good picture of DE&I in the financial services industry. So they couldn't really assess whether regulated entities were meeting with the spirit and intention. Again, this goes back to you passed this like pie in the sky kind of thing that was very fluffy. So what did you really expect to happen? But that's what happened at the end of the day. So if we go to the next slide. So it was against, you know, that backdrop that I think a lot of the discussion around 342 kind of calmed down, quieted for a bit, and regulated entities just kind of continued on their DE&I track. Great that it might make their regulator happy, but they weren't really necessarily fundamentally changing their program. Some did consider implementing them in response to it because they said, oh, wow, this is something that the CFPB, if they do an audit, might look at. And if we just have completely ignored this, you know, this topic, that might not be a great thing. But I don't know how meaningful of a change it really pushed on a lot of these entities at the end of the day. But certainly 2020, as Amber mentioned, really did, I think, fundamentally alter the way that organizations were looking at their DE&I programs and having discussions about the challenges that are, that everyone still faces today in this country. And so I think it put a much finer point on being thoughtful. We definitely saw a rush to introduce programs because everyone thought they needed to have one. And I certainly, for those of you on the call who are like, this sounds great, we want to do this, I would not do that. These programs need to be thoughtful. They need to be intentional. They should not be reactive and responsive. They should, be proactive, and you should be taking the time to figure out what makes sense for your organization. But a lot of organizations really invested a ton in their DE&I programs in the past 3 to 4 years. And then we get to last year with the Students for Fair Admissions decision, and after everyone felt like they were hitting their stride and their metrics, they're measuring change, and they're feeling really good about standing up their programs, the Supreme Court comes along, and if we go to the next slide, drives a big old truck through a lot of that. And in a case involving universities that were considering race in connection with the applications process, says that any sort of consideration of race is violative of the Equal Protection Clause and of the Constitution. And the view of the Supreme Court essentially was that eliminating racial discrimination and providing equal protection means exactly what it says. Both races must be accorded the same protection, otherwise it's not equal. And so any kind of race-conscious programs that would deny opportunities to other people who are not in whatever that racial category may be is violative of equal protection, because it is a zero-sum game. One person's taking the slot, which necessarily means another person is not. And racial balancing is just not constitutional. So if we go to the next slide. And in making this kind of decision, that prioritizing diversity and that kind of viewing diversity as a means to give preferential treatment to a particular race, a race or a classification that may be underrepresented is unlawful. They found that the goals of these university programs were standardless, amorphous, and immeasurable. Like, they weren't enough to justify treating someone differently on the basis of their race. And the reason why we list these out is that you could easily see how these bullet points don't just apply in the university admissions context. A lot of these bullet points are exactly the kinds of goals of a lot of corporate DE&I programs. The philosophy and the objectives are very similar. So it certainly causes some concern then for private employers in looking at this, saying, well, the Supreme Court doesn't view this as substantiating any kind of race-based or preferential treatment, so now we need to think twice about it. If we go to the next slide, it really tees up looking at this as like a side-by-side comparison from the educational context and the constitutional context to Title VII, and Section 1981. So if we go to the next slide, we kind of look at a comparison. So Title VI was at issue too in the particular lawsuit, but there's also Title VII and Section 1981, and they all prohibit discrimination on the basis of race, color, religion, sex, national origin. There are, varying protections in a number of the anti-discrimination lawsuits, but there's also a lot of similarities there. And if we go to the next slide, the Supreme Court justices weren't so far off from kind of drawing the parallels to these other employment statutes. So even though they were dealing with the Equal Protection Clause of the Constitution primarily, Justice Gorsuch expressly noted that the provisions of Title VII live right next door. And so the justices are thinking of the anti-discrimination laws in the employment context, even though they are addressing a constitutional issue and in a different context. And I think, for those who are so quick to say this is a really different context, it's not going to translate or it doesn't have an impact on Title VII, I think it really kind of belittles the point that the Equal Protection Clause actually allows potentially for different treatment on the basis of race, so long as you can pass strict scrutiny. So it actually is not a uniform ban on ever considering race. It's just, it has to pass strict scrutiny, and here the court found that it didn't. Title VII does not have that leeway. Title VII is a blanket ban. You cannot treat anyone differently on the basis of race, period. It's not, but you can if you have a legitimate business reason for doing it. You can't. So I actually think that there is a very decent chance that if this issue were at some point before the Supreme Court directly, that the result would be very similar, and that the language, in fact, it might be easier for some of these justices to overtly say that was a case where there was a possibility if they had done it better, more carefully, and if it was narrowly tailored. We don't have any wiggle room here. It says what it says. It's zero discrimination under Title VII. So I think that that's a really big thing for employers to consider in connection with this process. And one of the other things that I think further substantiates that is right after the Supreme Court decision came out, the Republican appointed EEOC commissioner issued a statement that, all but said treating employees differently or giving preferential treatment based solely on a protected characteristic in order to achieve an equal and balanced outcome or to align with some definition of fairness are asking for trouble. So I think that the EEOC, although it hasn't issued any like concrete guidance regulations in the wake of the Supreme Court decision, you have a lot of people that are analogizing this in the employment context. So we could go to the next one. Okay, I kind of covered that too. Let's keep going. So that leaves us in this sort of post-Supreme Court state and trying to figure out how do we reconcile the court's ruling with corporate DE&I programs. What are we supposed to do with the existing programs? Where are there potential problems? Does this change anything from a legal standpoint? And if we go to the next slide, we'll see, like I said, it didn't take long for there to be legal challenges to a lot of these programs. And America First Legal called out 17 national corporations for their DE&I programs, including entities that are regulated by Section 342. And they were also asking, writing letters to the EEOC for investigations, reverse discrimination. All of these companies giving preferential treatment to people in protected classifications. It's a violation of Title VII and the anti-discrimination laws. And a lot of the attacks focus primarily on those pillars that we were talking about, in particular, workforce. So whether it's hiring, whether it's promotions, things of that nature, and supplier diversity. So we started to see a lot of initiatives by organizations to encourage supplier diversity. Some went farther than others, and for example, may require that X% of their spend be on women-owned businesses, minority-owned businesses. Others had certain quotas for projects where you had to utilize a diverse vendor for a certain portion of a project, for example. So a lot of the attacks are in this space, and they are trying to utilize a lot of the dicta in the Supreme Court decision to support their position that all of these practices are unlawful under Title VII. And unfortunately, and we'll go to another slide in a minute, these organizations that are bringing these lawsuits, in particular America First, are leveraging the public disclosure, the transparency that Section 342 really strongly encouraged. Be transparent, put it out there, put it on your websites, disclose it to us, and are utilizing that against these organizations in connections with the filing. So whether it's through FOIA requests, whether it's through disclosures that are required under to the SEC, or other kinds of publicly available information, America First is culling all of the websites and utilizing this information to later sue these organizations for certain aspects of their DE&I programs. So if we go to the next slide. So I mentioned there's letters that are calling organizations out. There's requests for investigations. There's also actual litigation that is filed in a number of different circuits alleging various aspects of DE&I programs to be unlawful. Some of these, like I mentioned before, are shareholders, and they're asserting that the organization misled investors through DE&I executives, tying executive compensation to DE&I goals, etc. And some of those cases remain pending. Others are more specific, reverse discrimination, more individualized cases where individuals are suing the organization, claiming that they were discriminated against and on the basis of their race, and that disproportionate benefits, advantages, promotion opportunities were given to individuals in protected classification in furtherance of DE&I initiatives, which they claim are unlawful under Title VII. So if we go to the next slide. So this lists, again, some other pieces of litigation that are targeting various aspects of DE&I programs, workforce supplier and supplier diversity goals. Some have been dismissed as frivolous. Others remain pending. Further, others are remanded to arbitration depending on the parties' arbitration agreements. So they're all kind of still trickling through the judicial process. So we'll continue to see decisions come down, and I think they're going to be very fact specific. I think some judges are not going to find much merit to, I think, the really spurious types of litigation, but there may be instances where especially if an executive's compensation was tied to hiring or promoting a certain number of individuals in a protected class, and there's an individual reverse discrimination lawsuit, that could pass muster. I mean, there could be enough factual evidence there where it's a question for a jury to decide, was the decision race motivated? And if it was, that could be a problem under Title VII. So we're still seeing that play out. If we can go to the next slide. We're also seeing this play out in the political arena. I think add it to the list of a gajillion political issues that we're going to be hearing about leading up to the presidential election that will have us all, I think, wanting to bang our head against a wall, no matter what party you're affiliated with. But we're seeing this play out in the political arena too. And there's no question that when Trump was in office, he viewed DE&I programs a certain way. There's no question that President Biden views them in a very different way. So I suspect we're going to continue to hear more about DE&I programs and all of the sort of ancillary issues around them as we go through this election year as well. Go to the next slide. I alluded to this before. The EEOC, like the commissioners and the chair, have issued sort of dueling kind of statements and not really provided a ton of guidance at all. So we have basically like litigation, the agency is like, we don't know, and the politicians saying, don't do this, yes, do it. So companies are really in a great spot in terms of clarity, which leads to the next section of the presentation and the last section of the presentation. And that really is like the risk proposition. Like, what should you do here with all of this information? And if we go to the next slide, I've touched on it throughout the presentation, but there really is this tension. There's the tension between 342 with companies' traditional DE&I programs and this post-SFFA environment. You know, on the one hand, we're being told you need to be addressing the underrepresentation of women and minorities. And then on the other hand, the Supreme Court is saying, but racial balancing is unconstitutional. And then we're supposed to be focusing on, you know, organizational commitment to diversity, workforce initiatives, procurement and supplier diversity, but then there's tons of legal attacks on all of those initiatives, claiming that they're unlawful under Title VII. And then we have financial regulators saying, be transparent, share all this information, and then plaintiffs are using that to sue the very people who are just trying to listen to the regulators, telling them to be transparent. So if we go to the next slide. It makes it really challenging for organizations to figure out the right balance here. I do know that in the wake of SFFA, a lot of organizations have kind of conducted, it's not, I wouldn't even know that I would call it so formal, but maybe an internal and privileged, to the extent you can privilege these conversations, that's always helpful, conversation about their own DE&I initiatives. Like, let's catalog it. Let's make sure we know, like, what are our public facing statements? What are we doing in all of these pillars right now? Are there areas that are more higher risk, that might be low hanging fruit for plaintiffs' lawyers? Should we be reevaluating whether we want to continue certain initiatives right now in the wake of this sort of regulatory uncertainty surrounding the legality of some of the initiatives? And if we can go to the next one. So when you think about a risk assessment and we talk about it, there's a continuum. And I have clients really on the like full scale of this continuum. And there are plenty that are saying we're not going to make any changes and we're going to continue to go down the path and continue with the objectives that Section 342 says. And, ours are even broader than 342, and we're proud of that. And like, until a court says we're violating the law, business as usual. We have clients that are sort of like in the middle bucket that are like, we don't want to abandon this. This is like fundamentally important to our organization, but we also don't necessarily want to be the target, and we don't necessarily want to be on the front page of the paper. So how can we figure out that happy medium? And then there are other organizations that really want to avoid litigation at all costs for a variety of reasons and start to scale back on some of their initiatives. And so a lot of, I think, the important work that should be done is, weighing your risk. What is your risk tolerance? And, where are you potentially vulnerable? And what is some of the low-hanging fruit you might be able to revise or revamp without really abandoning your core mission, your core values? If we go to the next slide. So we give like an example here. Now, this is by no means like what you have to do, or there's no one way to look at this, but this is how I think a number of organizations with various variations have considered the risk proposition, because there are varying levels of what's risky based on the Supreme Court's decision. And so some of the questions you can ask yourself is whether the initiative expressly considers a protected class, or is it kind of neutral on its face? Is the initiative communicated, and how? Does it create this perception that it's exclusionary or preferential? Does it have an impact that is exclusionary or preferential? And has it been subject to a legal challenge? And I think based on your answers to these questions, you can kind of bucket initiatives. So so the one sort of like rule of thumb that I have is, if it's exclusionary or gives preferential treatment, you're going to be in the higher risk bucket. And the reality is the SFFA decision doesn't change that. That was always going to be a potential problem under Title VII, because there are a number of courts and at least one EEOC commissioner that says anything like the concept of equity and treating someone different so that they're equal is unlawful, because it's still a race-based decision. So you were always going to be in a more high-risk category if you were doing things that were preferential or exclusionary on the basis of any protected characteristic, not even just race, any protected characteristic. So I think a lot of organizations have tried to then redefine the opportunity. So if something before might have given an exclusionary or preferential treatment, or there was a program that was only open to a certain audience, they've redefined that audience. And so that everyone's eligible to participate in X, Y, and Z. And they've redefined what it means to be diverse. It's not just particular races or women or LGBTQ+, or some other category. It could be all of those things plus any individual who's overcome substantial life obstacles, who wants to gain this better experience from a leadership standpoint, or they define it where it's inclusive of everyone and it's not exclusionary or preferential. So there's ways, I think, to mitigate risk while still offering certain programs. But it does require this kind of assessment. So I think this is a good way for organizations to kind of bucket some of their initiatives. If we go to the next slide. So, and another thing to consider is, does it result in an adverse employment action? So that's of course going to be like the highest risk. It's exclusionary, preferential, and results in an adverse employment action. Like someone gets hired or someone gets fired as a result of X, Y, or Z, or someone gets promoted or not because of X, Y, and Z. So if it does, again, higher risk. So some DE&I initiatives are really far removed from employment decisions and terms and conditions, like training and outreach. And, you know, I was hearing Amber talk about all of the different cultural celebrations that they have. All of that is so far removed from anyone's career advancement, losing their job, you know, hiring, firing, and everything in between. So it's a lot lower risk than things like even diverse slates, or requiring there to be one woman on your board of directors, a quota, or things like that, that are very more closely related to employment decisions. So let's go to the next slide. And so here I gave some examples before. So some of the more vulnerable ones, like when we're thinking about relative risk, diverse slates, targets, you know, that's been subject of certain litigation, like you should have 10% of X in your workforce, or in this group, or on this team. Diverse internship programs, this is a really big one, and a lot of organizations have been sued over diversity fellowships and things like that. Again, there are ways to modify those programs and be able to continue to offer them. So I don't want people to feel discouraged if they've like finally stood up a program and now they're hearing, oh no, this might be problematic. There are ways to make it less problematic, but they certainly are a target for some litigation, to the extent especially that they were exclusionary or gave preferential treatment to certain classes in the past. Mentoring and sponsorship programs, same thing. And then developmental programs or leadership programs within organizations. So those are some areas that are worth maybe another look. Less vulnerable programs, I mentioned. All of these other great aspects, and frankly very critical aspects of DE&I programs, are far less likely to attract litigation attention and also be problematic from a legal standpoint under the law as it exists today. Go to the next slide. And then when it comes to supplier diversity, we kind of bucketed that too. Same thing. When you think of quota, targets, percentages, more risky versus outreach and connection building and mentoring programs, and, you know, providing lists of these suppliers, like access, things of that nature, less risky. Next slide. Again, just be mindful of what you're creating and who you're sharing it with, and whether you need to share it. But even if you don't need to share it and you think it will never see the light of day, it still might see the light of day. So just be really careful with how you're documenting things, and when you're making changes, try to maximize the privilege, involve counsel, so that you're covered from like the why behind certain changes in the event that there's ever a FOIA request or some other kind of information request and discovery. You would have a basis to withhold some information that could be used against you when you're trying to assess and evaluate all of these things. And with that, that concludes my piece. We're happy to answer any questions that anyone may have.
Yes, thank you. Thank you both, Amber and Meredith. That was a great webinar, great information shared for our attendees. If you do have a question for either Amber or Meredith, as Stephanie had noted earlier, you can type those questions into the question Q&A dialog box, and I will share those. So we do a couple of questions here, if I may share these. For Amber, on your DE&I Resource Center, who can attend the DE&I webinars? Is it MBA members only, or is it open?
They're open to everybody. We offer them complimentary for our members, but also non-members can attend. And when I use the word non-member, we do corporate-based membership. So by virtue of being employed with an MBA member company, you are a member. So that information, again, it's readily available to everyone, and all of our webinars are recorded and available for later listen and use.
Got it. I think that, Amber, this is also for you. Does the MBA see the industry being swayed to move away from DE&I, given the legal and political environment that Meredith shared with us?
Not from what I'm seeing, and not from what I'm hearing when I'm engaging with members. I think when you set out to establish a DE&I initiative, or an initiative that impacts everyone, I also think too, definitions are so important. I think oftentimes, especially now being politically motivated in the height of an election year, DEI is often equated to race. And that's not necessarily what we're talking about here. Yes, that's a component of it. Gender is also a component of it. Culture is a component of it. But how we live and how we work. MBA actually is in the midst of identifying kind of 4 different generations that are in the workplace together, and how we meet the needs of everyone. That's a DE&I initiative, and that has nothing to do with race. I mean, intersectionality for sure, but I think when you embark upon what you aim to do as an organization, I believe it has to be aligned with your values, and so you're less, I think, susceptible to be swayed from doing the things that are important to you and the culture within. Obviously, operating within a legal parameter. There are things, again, related to hiring and such. But I think a lot of the things we're talking about are motivating individuals, getting people to see one another for who they are, beyond what you can physically see in your gender and your race, and more about being more collaborative.
Right, right. Meredith, I got a couple of questions for you. For Meredith, does the current legal and political environment end the employee affinity groups for companies, affinity groups within companies?
Yeah, so I think it's a good question, and some of that depends on how the affinity groups operate, how they're defined. I know that, for example, at our firm, we have affinity groups, but they're open to everybody to participate, and everyone's allowed to participate, and in fact, I think is encouraged in many instances to come. There are rarely closed meetings of any sort. So I think again, when you're thinking about affinity groups, if it's open to everybody to join the affinity groups, I see zero legal issue. If it's restricted to individuals of a certain protected class, does it get a little bit closer to something that's maybe not ideal because it's, kind of a benefit of the employment? Are you making any kind of decision based on a protected class? Like maybe. But to me, most organizations that I work with open membership up to everyone. So there's zero legal issue with it.
Excellent, thank you. One more question for you, Meredith. Does the current environment make it a problem for lenders to intentionally hire minority loan officers to help them move and expand into minority communities?
So that was always unlawful. If the decision is based on the person's protected class. So Title VII prohibits making any kind of hiring decision based on someone's protected characteristics. So if under oath, answering that question, someone would say, I hired so-and-so because he's Latino, that's going to be a problem. That was a problem ever since Title VII was enacted, and it's still a problem. Now, there's a lot of different ways, again, legal ways to try and ensure that you're able to meet your business objectives without having overt directives to hire people of particular characteristics. So some of this is being smart about how you go about your business practices, but keeping in the back of your mind that the answer to that question was always needs to be no. We did not hire so-and-so based on X. So that's ultimately where you need to be. And that's always been the rub with a lot of the work in this space, especially when it comes to moving the needle with respect to certain underrepresented populations.
Excellent. All right, thank you. That concludes the questions that have been posed for our speakers. Again, thank you both for being a part of today's webinar, and I'll turn it back to Stephanie to close us out.
Oh, good. Thank you, Susan. Thank you again, Candy, and our sponsor, PC for Mercor. And thank you especially to our presenters, Amber and Meredith. I think we've really learned a lot, enjoyed our time together, and you've both given us valuable resources and especially in Meredith's presentation, things to unpack and really make sure that we're on track. And I do love the playbook, Amber, so thank you for that. So yeah, I think there's strategies we can all implement. And lastly, I would like to invite everyone to the California MBA DEI Committee Complimentary Network event at the offices of Wright, Finley, and Zach in Newport Beach on June 27th. And Susan did add the link in the chat. So I hope we will see you there. Hope you've enjoyed the webinar today.
Please join us on June 27th for that free networking event hosted by this committee and Wright Finley Zach. And that concludes today's presentation. This information to follow us on LinkedIn to hear more about our upcoming DE&I resources that we'll be sharing with you. And I wish everyone a great rest of your day, and we will see you next time.
Thanks again.
Thank you, everyone.
Thank you.
Thank you.